So one interesting recent case in this area that I thought I'd talk about is the case of Mulgrave School Foundation. In Mulgrave, several individuals made donations to the school in the amount of about $1 million for the use. The use was stated for establishing a scholarship program for students. The gift letters that accompanied the donations said that would only be used for that purpose. Around the same time, the authorities at the school were considering expanding the school and purchasing land next door to build a new building, but they needed some capital to do that. So what they did, they went back to the individuals who donated the $1 million and asked if they could use the funds instead of for a scholarship fund to fund the capital project. The individuals consented. They said, yeah, that's fine, we're happy to see it go towards the construction of a new building. But the school realized upon getting legal advice that they couldn't do this because it was a charitable gift for a restricted purpose. They couldn't unilaterally do that without getting the approval of the courts. So again, the people who made the donation consented to the court application and the order. But at common law, the court has legal jurisdiction to apply what's called the CPRE doctrine. This is the only way you can amend the terms of a charitable gift or trust. And it must be shown that the original purpose is impossible or impracticable to fulfill, and then the court will amend the terms. The provincial government opposed the application because they have the jurisdiction to deal with charitable interests on behalf of all of us. So they opposed this application, and they said the applicant's school was unable to trigger the main test to apply the CPRE doctrine, and that's showing that the original purpose was impossible or impractical because they had a scholarship fund and the money should have been used for that purpose. So they were ultimately denied the ability to transfer the funds to the new capital project. This case is important because it confirms when a donor has donated restricted funds, the donor loses any future capability to amend its terms, any control over the funds. And it confirms that the intention of the donor, even if it's after the fact, isn't enough to change it. You have to show impossibility or impracticability. So it really underlines the importance for charities to draft broad terms that would accompany a gift, giving them the authority to use the funds for whatever purpose they deem fit at that point in time. The next case I thought I'd talk about, another one from this past year, is Norman Estate and Watchtower Bible Tract Society of Canada. In Norman Estate, a husband and wife made a donation to the society in the amount of $200,000 and entered into a confusing agreement called a conditional donation agreement. The agreement provided that the funds would be given to the charity, the society now, but there was a demand loan accompanying the gift. And the demand loan provided that the donors could come back later and demand all or a portion of the loan back if they needed it for an emergency. On death, the loan would be forgiven and the charity would be able to take the money. After the donors died, the estate found out about the gift and the existence of the agreement, and they brought a court application against the charity seeking the return of the funds. And this position was based on the estate arguing that the agreement created a testamentary gift, not an inter vivos gift. And because it was testamentary in nature, it had to comply with all the requirements for preparing wills, so it had to be witnessed by two individuals and so on. And it didn't in these circumstances. So the court looked at all of the evidence and determined it was actually the intention of the donors to make an immediate inter vivos gift, even though they had this power to recall all of it prior to their death. So again, this case is important because it shows some of the problems that can occur with charities who do not prepare proper agreements. This agreement in particular didn't set out when the gift would take effect, and it should have said takes effect immediately. and then it's subject to this condition subsequent for the donors to recall the money. So now I'll talk about the main part of my presentation. That's on powers of attorney. Some of this might seem basic. I'm just going to outline what types of powers of attorney there are in Ontario and some of the key features. As we all know, wills are probably the most common instrument to make charitable gifts. However, powers of attorney can be utilized for a planned giving strategy. But in order for that to happen, they have to be drafted properly and in a flexible manner. If they're not drafted properly, your hands are tied as a substitute decision maker. As most of you know, in Ontario we have this substitute decision maker regime created under the Substitute Decision Act, and the Act sets out comprehensive rules for attorneys when they're acting as attorneys for incapable persons. And a power of attorney is just basically a legal document appointing another person to act under specified circumstances. It doesn't have to be prepared by a lawyer. You can go online and print them off and complete one yourself. But just like homemade wills, I think it's always better to have a lawyer advise during its preparation. So there are two types, if you just want to go back to the last one, two types of powers of attorney, property and personal care. Power of attorney for property permits your attorney to continue act. So there's two types, two subsets of powers of attorney for property, general and continuing. A general power of attorney is a legal document that lets your attorney act, manage your finances while you're capable. If you become incapable at some future time, it's null and void. And this is commonly used by our business clients, for instance, when they're leaving the country and they need someone to sign contracts or deeds. So it's time limited. A continuing power of attorney for property, it allows the attorney to act even when you become incapable. And to be valid, it has to state in the document itself that it is a continuing power of attorney. The second type of power of attorney you probably all heard of is the power of attorney for personal care. This allows someone to make personal care decisions when you're incapable. This includes health care and treatment under the Health Care Consent Act, diet, housing, hygiene, clothing, and safety. But today I'm just going to talk about powers of attorney for property. So this slide just outlines some of the key things you should know about powers of attorney for property. You can appoint anyone who's over the age of 18 years old to act. But some of the factors that I advise clients on when they're thinking about appointing someone, first of all, it should be someone that you trust, who's trustworthy with your money, and someone good with investment, business decisions, and so forth. Another key thing is make sure the person actually wants to act as your attorney, because you'd be surprised how many people appoint 2 or 3 people and they all say no when it comes down to it. Another key feature is to outline in the document whether the attorney is going to be paid, because there is compensation, and if you don't put it in the agreement, it's 6% approximately of the value of assets coming in and going out. And most of the disputes that I see are over compensation. So it might be one child acting and there's 2 other siblings. They all expect that sibling to act for free, and that's often not the case. So who can grant a power of attorney? You have to be 18 years of age and capable. And the Act actually sets out what capable means. So you have to know what property you have and its approximate value. Be aware of the obligations you have to other people who depend on you. The person has to know what they're giving the attorney the authority to do. They have to know that their attorney is required to account for the decisions that they make. They have to know that the power of attorney can be revoked in the future at any time prior to becoming incapable. They have to understand that their attorney does not manage their property well. If the attorney doesn't manage their property well, its value may decrease. And they have to understand that the attorney could always misuse the document and basically clean out their bank accounts. So it's important to note as well that a person can have capacity to grant power of attorney by satisfying all of those factors I've just mentioned, even though they don't have capacity to manage their finances. So oftentimes, we get a call from an advisor or a family saying, my mother or father doesn't have capacity, what do we do? Well, oftentimes people think you have to go to court in that instance, but in fact, even though they don't have capacity to manage their financial decisions, they might still be able to grant a new power of attorney. So what can a attorney for property do? They can basically do anything except prepare a will or revoke a will. Typically, attorneys perform all financial dealings on behalf of the incapable person, including banking, signing checks, dealing with real estate, and so forth. And finally, when is the power of attorney for property effective? Well, as soon as it's signed, it's a live document and can be used by the attorney, unless you put in conditions or restrictions. And it's our practice to always make it a live document, but then we hold it back at the firm, and we have an internal direction signed by the grantor telling us when we can release it. The other option is to put a restriction in saying it can't be used until you're incapable. But the problem with that is if a person does become incapable and you need a physician's opinion or a capacity assessor to meet with them, that stuff can take time. So we like to make the document live as soon as it's signed. So now moving on to gifting. The relevant legislative provisions are in 37 and Section 38 of the Substitute Decisions Act. And go to the next slide. Working backwards, but Section 38 basically just says, and I've bolded Section 37, which is the gifting provisions. It says those provisions apply to attorneys under continuing power of attorney only if the grantor is incapable of managing property or the attorney has reasonable grounds to believe that the grantor is incapable of managing property. So as a result of this provision, the gifting provisions that I'm going to talk about are only applicable if the grantor is incapable of managing property or the person has reasonable grounds to believe they are. By implication, this means that the expenditure provisions and gifting provisions are not applicable if the grantor still has capacity to manage the property. Section 37, which is the gifting provision I'm going to talk about today, is quite long, so it's over a few slides. But subparagraph 1 sets out a list of required expenditures that an attorney must make, and it uses mandatory language. It says shall instead of may. So the attorney is obligated to determine these expenses and make them from time to time. So the expenditures are, first of all, those that are reasonably necessary for the person's support, education, and care. Secondly, the expenditures that are reasonably necessary for the support, education, and care of the person's dependents. And finally, the expenditures that are necessary to satisfy the person's other legal obligations. If you're acting as an attorney and you don't make these expenditures, you can be in breach of the Act, and there's damage repercussions if you don't actually perform your job properly. And sometimes we see this where attorneys are also beneficiaries under a will. It's sad, but it happens every now and then where rather than spend money on dental care and things like that, that's more personal care, but rather than honor these obligations and make these expenditures, they want to ensure their inheritance is going to be there when mother or father passes away. So the next part of the provision is subparagraph 2. And the first rule is that the value of the property, the accustomed standard of living of the incapable person and his or her dependents, and the nature of any other legal obligations must be taken into account by the attorney when they're making the expenditures. And then it goes on to set out a hierarchy based on the expenditures we just talked about. So first of all, you look at the person and you make expenditures that are relevant to that person's support, education, and care. Only if there's money left over do you go on to the next step, which is dependents of the incapable person. So this might be a minor child or a spouse. And then finally, if there's any property left over, you can make expenses to fulfill other legal obligations. The next part of Section 37, subparagraph 3, deals with gifting and charitable gifting. So it says, an attorney may make the following expenditures from the incapable person's property, gifts or loans to a person's friend and relatives, or charitable gifts. So unlike the slide we looked at earlier where it was mandatory language, this is permissive. It's not, the attorney's not bound to make these types of gifts, but they have that discretion to do so. The next part of Section 37, subparagraph 4, the legislation sets out some rules that apply when you're making a discretionary gift under subparagraph 3. So first of all, there must be sufficient assets to satisfy all of the expenditures noted in subparagraph 1. And secondly, if gifts or loans are made to the incapable person's friends or relatives, they can only be made if there's reason to believe that based on the intentions of the incapable person while they were capable, he or she would have made them prior to becoming incapable. And this second part of intention is where we see most of the disputes in the case law, considering this provision. The next part sets out some guiding principles or rules that are restricted to charitable gifts. So charitable gifts can only be made if the incapable person authorized the making of the gifts in a power of attorney document executed prior to becoming incapable, or there's evidence that the person made similar expenditures when capable. So it's important to know, unlike gifts to family members or friends, intention doesn't really matter. What you need is an express statement in the power of attorney document in the form of an authorization or a pattern of gifts leading up to incapacity. The second rule related to charitable gifts at number 4 states that if a power of attorney executed by the incapable person before becoming incapable contained instructions with respect to making of gifts or loans to friends or relatives, the instructions shall be followed, subject to paragraphs 1, 5, and 6. So this just means that if you make the discretionary decision to make a gift to family members or charities, you're bound to follow any terms that are set out in the power of attorney document. The final two rules are 5 and 6. So 5 says the gift shall not be made if the incapable person expresses a wish to the contrary. So this gives an incapable person the power to overrule an attorney. So even if they had a pattern of donating to a church for every year leading up to becoming incapable, they can overrule their attorney even though they're incapable. The total amount or value of the charitable gift made by an attorney shall not exceed the lesser of 20% of the income of the property in the year in which the gifts are made, and the maximum amount set out in the power of attorney. So this is just a guideline that attorneys must follow when they decide to make a discretionary gift. The final part of Section 37 just provides a method for an attorney to increase a charitable gift or a gift to family members and friends by making an application to the court. I haven't seen much of this in my experience. And it also goes on to state that the expenditures made under this Section 37 are deemed to be for the benefit of the incapable person. Obviously, if they're giving a donation or a gift to someone else, there's an argument that the attorney's not acting in their best interest, but this sort of clears up that problem. And now I'll talk just a little bit about some case law that is considered Section 37. So the first one's Costello and Costello Estate. In this case, the husband was a power of attorney. It was a blended family situation. And he transferred his incapable wife's interest in the family home and a cottage to his daughter from a prior marriage. Her beneficiaries obviously opposed this once they found out. And they brought a court application saying the father exceeded his powers under the power of attorney and violated the act. And the issue for the court to determine was whether or not the incapable wife, while she was capable, expressed an intention to donate or give these properties to her stepdaughter. The stepdaughter who received the property pointed to the fact that during the 80s before, and this was about 20 years later, but during the 80s, her mom said, "Oh, don't worry, everything is going to go to you." But in the end, the court held that there was no indication when that gift was to take place in light of those statements. and that the term everything was too vague. Who knows, it could have included the contents of the home, her bank accounts, and so forth. So they didn't give much weight to that prior expressed intention. They also said that if the wife had intended a gift, there would have been some evidence of a paper transfer, or she would have mentioned it when she met with her lawyer to draft the powers of attorney. So the court made the following statement, that the law is very clear that an attorney under a power of attorney has no power to transfer property belonging to a donor except to give effect to a gift already made. The onus is on the defendant to prove that a gift was intended. The next case I'm going to talk about briefly is Jacob's estate in Hirshhorn. In this case, the attorney transferred the sum of $35,000 from her incapable mother's bank account to her own account and then bought a GIC in her own name. Based on the principle in the previous case, the daughter obviously had the onus to show that her mother intended for that gift to occur. And the daughter said, well, the transaction was carried out based on the intention of her mother so that she could contribute to RESPs for her 3 children, but she admitted that there's no independent evidence or documentary evidence to corroborate her evidence. So because of this, the court held that the deceased expressed no intent to make the gift. So the court said the deceased had no intent to make the gift prior to becoming incapable, and the transfer was thus a clear breach of Cheryl's fiduciary duty owed to the deceased and her duty not to use the power of attorney to benefit herself. And it's important to note too that this would be considered a breach of fiduciary duty, and the big thing with that is if you're transferring, making gifts to family members, the attorney can be held personally responsible to the extent of the funds transferred. So you know, it's a big risk for attorneys in making these gifts because they might have to repay it in the future. I guess it's the last case I'll talk about is Robertson and Hayton. So in this case, the attorney for property withdrew $6,000 from a joint account of her parents. She had power of attorney for them and put those funds into her own bank account. The attorney also received a $79,000 check from her dad and then put the funds into her own bank account. The attorney argued that both of these amounts were transferred to her as gifts under the power of attorney and that her parents intended to make these gifts. And in reviewing the law, the court made the following statement. It said, the standard of proof for intention to donate is high. The donee must show that the transaction was a gift by proving a clear and unmistakable intention on the part of the donor to make a gift to the donee. In weighing the conflicting evidence, it is not sufficient that the preponderance of evidence may turn the scale slightly in favor of the gift. The preponderance must be such as to leave no reasonable room for doubt as to the donor's intention. It should be inconsistent with any other intention or purpose. If it falls short of going that far, then the gift fails. So this statement by the court showed that in these circumstances, it's more like the criminal, no reasonable doubt. It's a high level of evidence you have to show to show there was a gift that was made. And that's different from normal civil cases where you just have to show enough evidence so the court swayed 50% plus 1 that there's enough evidence in favor of the plaintiff. So certainly a high standard when we're dealing with gifting under powers of attorney. And I think this is based on the fiduciary responsibilities of attorneys, and obviously there's potential for abuse there. With respect to the $6,000 gift in this case, the court just said, well, there's no evidence whatsoever, and the affidavit evidence from the attorney cannot be given any weight. And this is based on Section 14 of the Evidence Act, which says that an interested party shall not obtain a verdict on his or her own evidence in respect of a mentally incompetent person unless such evidence is corroborated by some other material evidence. And the court said here there was no such corroboration. With respect to the $79,500 gift, there was actually a family friend who delivered an envelope from the father to the daughter that apparently contained this check. And at first instance in the family friend's affidavit, she said, yeah, the father said to me, please take this to my daughter, Karen, I want her to have the money. However, on cross-examination at trial, she admitted she had no idea what was in the envelope. So the court held that at the time the check was delivered, the daughter, she was doing the father's banking, so it could have been, just as likely that he was sending her the money so that she could invest it on his behalf and manage his finances. The court also had doubts about the individual's capacity. So they said, I have serious reservations regarding whether the father had the capacity to make the gifts in question. The medical evidence showed steady deterioration of his condition, both physical and mental, since the beginning of 2001. There appeared to be days where he was lucid and days where he was not. So in the end, the court said there's insufficient evidence to find there's a prior intention to gift. Next one. So I guess the next slide, I just put in some language that we often put into powers of attorney for property to deal specifically with gifting. So this statement here, we often put in, again, it complies with the Act, but it also, you can adjust it for each client. So it says, I hereby declare that my attorney may make gifts and loans to my relatives and friends and may make charitable gifts from my property, subject to the guiding principles set forth in the SDA and in accordance with the following guidelines. So again, these can change based on the client and what they're looking for, but in this case, it says gifts may be made to a grandchild of mine for the purposes of furthering that grandchild's education, provided the gift is approved by a majority of my children who are adult and capable. Gifts may be made to any charity to which I've made a donation in the 3 years immediately before my attorney begins to act, but no single charity should receive more than $10,000 in any calendar year. And of course, you can adjust that amount. The provision we looked at earlier says you can set any monetary threshold that you'd like, so long as it's in your power of attorney. And then in this one it says, under no circumstances shall my attorney make a charitable donation to any religious institution or any charity with religious objects. The next one really just allows your attorney to, gives your attorney more flexibility in making charitable gifts, especially when it's done for estate planning purposes and to lower taxes. So it says, my attorney is authorized to undertake estate planning for the purposes of reducing taxes potentially payable on my estate or for such other reasons as seem sufficient to my attorney, having regard to all the circumstances, including my best interests and the interests of my spouse, children, and grandchildren, and such expert advice as my attorney deems helpful. My attorney is authorized to transfer assets, including the share capital of any corporation owned by me, into my attorney's name, or to make gifts of share capital, loans of corporate assets, or other transfers of property of any size or value to one or more of my spouse or my children, or to any charity or trust for my benefit and the benefit of others, all as to my attorney seem most prudent in the circumstances. I declare that any such gift or transfer made by my attorney is a gift that I would have made if at the time I were capable of so doing. So this one's important if you have high net worth clients that really want to take advantage of a donation scheme while they're incapable. People are living longer now. The age expectancy for, I think, women is 86, men 84, or 86 and 84. And certainly people are living longer, but there's mental illness and dementia and other issues that are becoming more common and more prevalent. So this one's great. You really have to put trust in your attorney because you're giving them full authority to make donations of any size. I wouldn't recommend anyone appoint someone as power of attorney if they don't trust them to act on their behalf. But this is a really good clause that we often put in powers of attorney. And I guess that's it. So I guess the two things I wanted to stress today. First of all, from a planning perspective, charitable giving should be considered by clients when they're making a power of attorney. Oftentimes, lawyers, advisors just rely on form documents, but if you don't actually dig into, the intent and consider charitable giving and, tax benefits and all of these estate planning benefits that can occur, I think you're really, not acting in your client's best interests, and so that's important. The second thing, of course, is if you're advising clients who are attorneys for incapable persons and they're considering making a donation or gifting assets to family members, You should tell them there's, comprehensive rules set out in the Substitute Decisions Act, which we've reviewed, and any wrong step could result in them being in breach of their fiduciary obligations and having to repay the gifts. So it's always good to get legal advice if they're considering making a donation in those circumstances. So that's it.